Welcome to Appointed.
Well, I can't say good morning and good afternoon, but I'll say good day to you. We're joined today on Appointed by the Honourable Chancellor Marion Buller, former Chief Commissioner of the National Inquiry into Missing and Murdered Indigenous Women and Girls, and now Chancellor of the University of Victoria. You have done amazing work, in addition, of course, to being the first Indigenous woman judge in the province of British Columbia. And I am overjoyed that you're joining us today because the perspectives you bring, the background you have, the incredible expertise and experience are really unparalleled. And so I'm very, very pleased that you're able to join us today. We wanted to speak to you about two things. One is the guaranteed livable income and guaranteed income that was recommended as Call for Justice number 4.5 in Reclaiming Power and Place, the final report of the inquiry into missing and murdered Indigenous women and girls. And we, as you may know, we've already spoken to the Honourable Murray Sinclair, as well as Dr. Nigan Sinclair about this. There are many others. I'm working with Leah Gazan on the same bill. She introduced it in as Bill C-223 in the House of Commons, and I introduced it as Bill S-233 in the Senate. And so really, one of the things we wanted to talk about is what was it that really caused you and your colleagues to make this as one of the calls for justice when you were looking at the whole issue. I've often talked about the fact that you so clearly identified the issues that give rise to so many Indigenous women and girls going missing, being murdered, ending up homeless are the same issues that result in them being imprisoned as well, and in otherwise institutionalized. And I'm wondering if that had something to do with it, but over to you.
Well, first of all, thank you, Senator Kim, for inviting
Just call me Kim.
for inviting me to be with you today. It's an honor for me to be with you because I know your background as well. So having said that, thank you very much for the opportunity to comment. One thing that I want to point out was when we made our various calls for justice, we were looking at so many different issues that are interconnected. But a common denominator in so many of the issues was poverty. Going to housing, going to education, going to healthcare. It just seemed to be one of our very common denominators. And it seemed like so many problems or issues could be addressed by a guaranteed annual livable income, and emphasis on livable, because an amount in Southern Canada wouldn't be adequate in Northern Canada, for example. So livable is a very important word. But we just saw so many times how people were committing offenses because of poverty. And so they get into that revolving door of the criminal justice system. There are people who were not having adequate diets. So then they get into the revolving door of the healthcare system. People who couldn't afford proper housing, for example, faced so many different issues regarding security, having to live on the streets, for example. So many women couldn't keep a roof over their heads based on the income that they were receiving, which was not adequate. And so it just was, and then movement into human trafficking and the sex trade industry. So poverty was an issue that came up time and time again. It didn't matter First Nations, Inuit, Métis, off reserve, on reserve, Eastern Canada, Northern Canada, Western Canada, didn't matter. This was a common theme in so many of our hearings and in so many of our findings as well.
Oops, sorry. You'd think I'd learned to unmute and mute myself by now. The links between that kind of ongoing systemic poverty and colonialism are also woven throughout your report. And one of the things that really struck me is if we were committed to the UN Declaration on the Rights of Indigenous Peoples, in some ways this would be a no-brainer because we would be already having these discussions. And so I'm curious as to, how do you see the links between the work that's being done on UNDRIP and the work, the links between your calls for these kinds of economic, social, political security, if I can put it that way, are linked, and in terms of how do we see those all intertwining to create a better future for Indigenous women and girls in particular. And you've mentioned very much, I mean, I can't tell you how often I hear from women coming out of prison that the only work they can go to is to go back to trading their bodies, to have a place to stay, whether it's in exchange for a roof over their heads or a meal. And so the challenge of not having that kind of autonomy, not just economic autonomy, but bodily autonomy sometimes, and the ways that gets glossed over oftentimes in discussions, about how do we create these supports and talk about access to justice in very holistic ways, not just in ways that are seen through the eyes of privileged white people who have never experienced those lives.
Huge issue, Kim. Very early on in our calls for justice, I believe it was 1.1, we said this what we need to do as a nation is a complete paradigm shift in how we think. And one of my biggest fears is that we're looking at UNDRIP from a colonial view or through a colonial lens of how do we make it, is this another route for making Indigenous people fit into a colonial scheme, economic, political, social scheme? That's my biggest fear. What we need, as I've stated, is a complete paradigm shift, understanding, interpreting legislation, interpreting international statutes, for that matter, international instruments, through a rights lens, a human rights and Indigenous rights lens, so that when we're looking at the implementation of UNDRIP, we're not saying that this is a venue for new programming and new projects that can be taken away at the whim of a colonial government. We're saying, as a state, as Canada, we acknowledge that these are rights, human and Indigenous rights, and we must, as a nation, uphold and protect those rights, which is a paradigm shift away from, well, this is a nice opportunity for a new funding for new project, time-limited projects under UNDRIP. And so that's my concern, that we're just giving another route or another venue for Indigenous people to fit into the Canadian colonial state.
The work that you and I and so many others have been doing for decades now intersects in lots of ways. And the other area I wanted to talk to you a bit about was the miscarriages of justice that result from that. And you've already mentioned that. You talk about the number of people who end up, because of poverty, not just but sucked into the criminal legal system and criminalized and imprisoned, and the way that cycles through. And we're going to have in the links to this podcast, of course, the Missing and Murdered Indigenous Women and Girls Inquiry report and those resources. We're also going to link the report that we did out of this office, the injustices and miscarriages of justice experienced by, we talk about 12 Indigenous women, and that really came as a result of the work that Justice Harry Laforme and Justice Juanita Westmoreland Traore were doing. And that links very much with the work that you and your colleagues did on the inquiry. And these are women, some of whom would have been included in your report as well. And like in your report, they wanted anonymity because their trust in the legal system is understandably absent. These are women who all were convicted of serious violent offenses. Some of them not until they got into prison. The only time that they were convicted of violent offenses was once they got to prison, but all of them ended up, as a result of those injustices, serving either life or indeterminate sentences. And these are women that I've known for decades, and so there are many more than these 12 who have experienced injustices. But a thing that a lot of people are surprised by, in fact, I was just talking to some colleagues in the past few days about the injustices experienced, and many people didn't realize that even though more than half of the women in prison are Indigenous right now, in federal prison, and the numbers go up higher. There are 7 in 10 and 8 in 10 and 9 in 10 in Saskatchewan, Manitoba, and the North, and 3 Northern Territories. And when you look at young women and girls, they are actually 9 or 10 out of 10 of the youth in Saskatchewan, Manitoba, and the North. And so we know the injustices are rife. You can't have those numbers and not know there's something seriously wrong with our system. But many don't know that the majority of them are also convicted of serious offenses and violent offenses, either taking responsibility for their partners or their brothers or their uncles or their fathers, or not putting forward the whole story about what happened, sometimes because of feelings that they have familial or cultural or community responsibilities for the person who actually did the crime. And I think of two of the cases that are very public right now, Adelia and Narissa Cuisance, who were took responsibility because they were with their younger cousin, even though he was the one who actually killed the man that they were all convicted in relation to. And I'm curious as to how you saw these linked when you were doing the work, because I know from our discussions you very much see them linked, and I know from reading the report, all of you made those connections. Why do you think it's so hard for folks to understand, who are outside of this system, the general public, to understand that in almost all of the cases of women who have committed violent offenses, they're actually fighting for their lives, they're fighting for survival. And I have met one woman in 45 years now of doing this work who committed a predatory act of violence, and by that I mean someone who actively went out intending to cause harm and acted alone, wasn't first a victim of the person who became an accessory to someone else who had first victimized her. Now that's pretty shocking to many people to realize that that's 1 in 45 years that I've met. And I've met a whole lot more in the system when I worked with men, I have to say. But even there, the numbers are much more limited than people think. How do you see them linked, and what do you think are the steps forward that we could be taking that would actually address some of these issues? And I'm not asking you to repeat all of the incredible, insightful and thoughtful calls for justice, but are there steps you think that people like me could be taking that would help open folks' eyes or encourage them even to read those reports? I mean, I'm shocked by the number of people in this country who haven't even read the summaries of the TRC or the MMIWG reports.
Well, how to bring this into all of these issues into the mainstream is a question I don't know if I'm qualified to answer. But I think what we have to do is start understanding how people get there. And going back to the issue of poverty and guaranteed annual livable income, what we have to understand is that historically, and even still today, children of various ages are being removed from their families who love them very much because of poverty, because the parents or parent doesn't have a week's worth of food in their kitchen cupboards, assuming they even have a kitchen. So we have to understand that poverty is one of the main, has been and still is one of the main drivers for kids getting into foster care all across Canada. And so where do those kids end up? A lot of them end up running away in the streets, fending for themselves as best that they can. Some of them, there's so many off ramps that aren't good for kids who are in the child welfare system, especially Indigenous kids in the child welfare system. And as a judge, I saw this progression over the years where a child would be removed from their parents' care into foster care, committing offenses for a variety of reasons into the youth criminal justice system. And from there, they graduate into the adult system. And so I think we have to sort of circle back and understand the impact of poverty and the foster care system as the beginning of institutionalizing Indigenous kids who then become Indigenous adults. That's a bit of an aside because it was a point I wanted to raise with you. And it's a common theme all across Canada, not only my experience as a judge, but with the National Enquirer, we saw that. But I just want to share one comment, and I hope it's not out of place. It was an observation made by Commissioner Brian A. Olson when we were working on the penitentiary corrections part of our work, that the women that we were talking to weren't criminals. They were simply fighting back against colonization of them. And I thought that was brilliant. Well, one of Brian's many brilliant statements, but that's what they do. They're fighting against colonization. They're fighting to be recognized for their own humanity. And so the state is incarcerating them for fighting back against the state, which I thought was a really interesting observation, again, on Brian's behalf. And so how to bring these issues into the mainstream is very difficult because you're opening a Pandora's box on how dysfunctional the state is, how rampant colonization is, and how difficult it is for individuals to fight back against colonization without being sucked into that very child welfare, incarceration, correction system. So the state is penalizing people in a very severe way for fighting back, for their own, fighting for their own individual human and Indigenous rights. That's why they're in jail.
Yeah, no, it's so true. And I often say the rate at which we incarcerate people is really a function of how we have failed and how every system that is supposed to be put in place to support people, when they fail, the only system that cannot refuse people ends up being a prison system. And it's not accidental that we have more young people in the child welfare, more Indigenous young people in the child welfare system than we did at the height of the residential schools. And that those are, as you've already identified, and as you've mentioned that Brian did as well, that these are pipelines directly into our prison systems. And the other piece that you and your colleagues commented on was Call for Justice 5.14, which was around mandatory minimum penalties. And I'm often struck by, I don't refer to Section 718(2)E as Gladue factors, in part because Jamie Gladue didn't get the benefit and doesn't like that they're named after her, but in large part because they cloud the racism and the colonial racism and misogyny of what happened to Jamie. Because as you know, she was a 19-year-old described as an Indigenous woman, very young Indigenous woman, pregnant with her second child by a very abusive man who had moved her, had been jailed already for assaults on her, had moved her away from her support systems from Alberta, from Calgary to Nanaimo on Vancouver Island to get her away from her supports. Her dad, who was a single dad, followed her with some of the other siblings to try and keep her safe. And the night that she stabbed her husband, or her common law, and he died, he had first beat her up, then gone next door, broke in through the bedroom window, raped her sister, came back, and when Jamie stabbed him, he was trying to get back in through the front door of the unit where her sister was and her other siblings. And yet she's described, students, law students and lawyers for that matter, judges for that matter, reading the case, she's described as a jealous wife who stabbed her common law because he was having an affair. I can't think of a more racist, misogynist interpretation of those facts than she received. And now, because of mandatory minimum penalties brought in after she was sentenced, she couldn't even get the conditional sentence that she was sentenced to at the time. One, in my humble opinion, she should at the very least have had opportunity to have the defense of other, and if not self-defense, at the time. I think the charges should have been stayed as soon as they knew about that violence and knew the actual facts. But it was clear that, and we all know that the only reason it went to the Supreme Court of Canada, because it was the first judicial interpretation of Section 718(2)E, and the judge erred in saying it didn't apply to her because she didn't live on reserve. And that was the only legal point considered, not the fact that why was she even charged? Why was she prosecuted? Why was she even sentenced? How did we end up in that place that everybody involved in that system saw it through those misogynist, racist eyes? And so, all of the women in this report were subject to mandatory minimum penalties. And so even when judges had information about the injustices they had experienced, they had no jurisdiction other than to make a constitutional challenge to actually sentence them to anything but the mandatory minimum penalty. And so I'm curious as to, a lot of people were surprised to see that in the report. I was incredibly pleased to see it in the report. And I'm wondering if you can talk a bit about the backdrop to that. I mean, you already have in terms of some of the issues, but if you can speak a bit more as to why you saw that as so important to put in a report about missing and murdered Indigenous women and girls.
Oh, I could go on for hours, Kim. Where to start? It starts with the call to, it starts well before the call to 911. Let's flip the Jamie Gladue situation around and say, where did the state fail to keep her safe? It's victim blaming in its worst possible way, in my view. Let's flip it around and say, okay, was there a restraining order against the common law partner? If not, why not? Not victim blaming, but saying, why didn't the police or why didn't the state intervene earlier on to keep her safe? So there's been at least one, if not more, failures of the state to keep her safe, either because of her own experience with the criminal justice system. She didn't feel as though the justice system would keep her safe. There's that option. Her personal experience. Why didn't the police intervene? Why weren't other people involved in intervention even before it got to that state in Calgary, for example? Why wasn't a transition house or a safe house available to her where she could go to be safe? Why did she have to remain in that relationship? What options did the state give her to remain safe? I mean, we can go through the minutia of that analysis, but rather than victim blaming her, and incarcerating her for what she did. Let's examine where the state failed. And that never happened in that case, and doesn't happen in a lot of sentencings across Canada, because we blame the offender for their actions. We don't look at the systemic factors, the state imposed factors that brought the person into that courtroom to start with. And I think that's what the Gladue factors, I'm sorry to use that term, were meant to address, is how the heck did this person get into court? And why did that person get here? And and it takes great courage on the part of lawyers and judges to put the brakes on and say, no, this simply isn't good enough. We need to address the issues that brought this person to court. And if it means taking the courage on the part of a lawyer or a judge to say, no, I'm stepping outside of the mandatory minimum sentence here for these reasons, that takes great courage, and it takes great advocacy on the parts of both Crown and defense to enable the judge to do that. So, and which leads to a whole bunch of other failures of the state, systemic failures, as to why that doesn't happen. And I can tell you from my personal experience as a judge, being in a busy courtroom where I have over 200 matters on my list. How do I get through that list and put the brakes on with every one? I can't do it. I cannot do it. So, right. But the question is, why do judges end up with such big lists? So anyway, you've raised some very important issues. And this all leads to wrongful convictions or wrongful sentences. So going back to your initial question about how do we get this into the mainstream? How do we get people interested? I think that there should be televisions in courtrooms more often, because look at what the broadcast of the O.J. Simpson trial did. It raised the consciousness, it raised the awareness of the whole world about your ability to buy justice, or injustice, depending on which side you're sitting on. I understand the reluctance of the actors, the players, but I think now, we have to accept the fact that this is 2024, and people learn by and start to understand issues if they see it on a screen. And so we have to accept that's that reading it in studies is important. Having it in the old style newspapers, very important too. But what if the Bernardo case was televised daily? I mean, it put people to sleep at times, but what if that had been televised? What if the sentencing or the trials of a myriad of other people, maybe not Picton, well, maybe Robert Picton, maybe if his sentencing was televised, that would raise awareness, because we're very fast to pick up a screen, a YouTube video or a TikTok or whatever else we have now. We're less likely to read a report. Yeah.
Those are very astute observations. Sorry, I interrupted you.
It's okay. I think I'd finished on that anyway.
Okay. Yeah, very astute observations, because you're right. And the pieces that sometimes get attention is when sections of what has happened in court get publicized by someone taking the words of the actual lawyers or judges or the individuals who were witnesses or accused and broadcasting those out. It has raised huge attention. And I remember not a court case, but the inquest into the death of Ashley Smith. Part of the reason a lot of people know about it is because Ashley's mom wanted it broadcast and insisted that it be provided live streamed so that the entire world could see it. And now it's now, you know, more than 12 years ago since that happened, so it's not as fresh in people's minds. But at the time, people were very aware of what had happened to Ashley Smith, in large part because those images were, and the witness testimony was put out there. So I think those are very astute observations. And you know, I know that you continue to do this work. I think the work that you are contributing to as Chancellor and that the University of Victoria is doing around Indigenous education overall is significant. And the opening of the International Indigenous Justice Indigenous Center will be a huge component of that. And I want to thank you very much for your lifetime of work, and it's not like it has ended, it continues, and the many contributions you make to this and so many other areas. So thank you for that. And if there are any other final things you want to add that you want to encourage our listeners to focus on, and I think we're posting on YouTube as well. It's always the incredible young people who come to the office like Nicola and others that really keep us alive and out there getting this information. So I want to thank you too, Nicola, for setting all of this up, and for and Emily, who is not on screen but has been part of organizing this as well.
Yeah.
Thank you for all your work.
Well, pardon me for interrupting. Yes, thank you. You have a wonderful, wonderful staff. There is one thing that I would like to add. I'm back practicing law part-time with the law firm Miller Titterley, and I have to say it's just delightful to work with young lawyers, especially young Indigenous women lawyers who are absolutely brilliant, scary smart. And, you know, Kim, you wonder when I stop working, what will happen to my work? And I think we can be very confident in the fact that there are young advocates, whether they're lawyers or not, whether they're Indigenous or not, who are very committed to continuing the work that you started, of course, over your years, and the work that I started as well. So, Kim, I think we're in good hands.
I agree. Thank you for that, and thank you for reminding. And kudos to all of you out there who are continuing this work, as some of us get a little longer in the tooth.
Just a little longer.
Just a little. Thank you.